My name is Frank Ally. I'm a licensed California attorney dealing primarily in family law matters. This is the third part of an episode about dealing with establishing parenting time plans. Specifically, this episode is going to discuss how do we set up an initial parenting time plan after the parties have made a decision to separate. What do we do with the kids to start? Now let's get started. In making an initial custody determination, the trial court has the widest discretion to choose a parenting plan that is in the best interest of the child. Family Code Section 3111, linked below, lists specific factors, among others, that the trial court must consider in determining the best interest of your child or children. These things include the health, safety, and welfare of the child. We discuss in a future video linked below. A history of abuse by parents against the child or other parent, linked below. And the nature and amount of contact with both parents. Let's take a step back and look at the big picture. Specifically, how are we going to figure out what's best for your kids in terms of parenting time? Well, guys, the best way to do this is mom and dad agree. Remember, you both love your children. You both know your children. You both know deep down inside what's best for your child. It's better for you, mom and dad, to determine a parenting plan for your children and not rely on a judge who's going to spend 5 minutes reading pleadings and listening to some arguments. An evaluator or therapist who may spend an hour with you before they make a recommendation. Or between two attorneys who are charging you by the hour, arguing back and forth on what's best for your kids that they've never met and probably will never meet in their life. Please make an agreement. But if you don't, the court has to decide. And what they're going to do is they're going to look at the declarations of each party. Both of you are going to write declarations. Hopefully you're going to focus in on the facts and not deal with the drama. But the court's going to read what you said, what she or he said, and make a decision on that. You can go to mediation. In mediation, the two of you sit down with a trained mediator, sometimes court appointed, sometimes independent, and have somebody else help you work through an agreement what's best for your kids. If none of that works, the court's going to send you to an evaluator. Each county has different systems for evaluating. Some make recommendations, some don't. But again, you're going to spend an hour with an evaluator and they're going to tell you what's best for your kids. Wouldn't you rather have that decision yourself? Lastly, if you guys can't cut through the drama and you can't work together to determine what's best for your kids, you're going to go to trial. And at a trial, you're going to hear evidence and witnesses. And then the court's going to have to weigh all these factors and determine what is the best interest of your child. I'm Frank Ally. I'm your ally in family law. I want to help you solve your problems, but only you can do that yourself, particularly when it comes to your kids. If you like this episode, please like it, share it, subscribe to it, or buy me a cup of coffee.